Добрый день, уважаемые коллеги, дамы и господа. Я приветствую вас на круглом столе.
Good afternoon, ladies and gentlemen, dear colleagues. I would like to welcome you at our roundtable discussion, legal aspects of the financial regulation reform. And we're going to look at the regulation in the light of the international financial crisis. Before we begin, I would like to introduce the speakers. Svetlana Ichevskaya will do the same for the second round of the session. So I'll begin introduction from my left. Svetlana Ichevskaya, Director of the Legal Department of the Ministry of Finance of the Russian Federation. Before her time with the Finance Ministry, she used to be in legal profession, just to be a lawyer, and also work for the Ministry of Property Relations, so the Federal Agency for Property Management. She has been with the ministry since 2002. 12. So just the reform effort was the one that she basically witnessed from beginning to end. The second presenter is Antonia Sainz de Vicuna, Director of Legal Department of the European Central Bank. He has rich experience. He used to work with legal bodies of Spain, also represented the banking sector of Spain, and then he went to serve for the supranational bodies like the European Currency Institute, that was a predecessor of the European Bank, and just now he is with the Central European Bank for a number of years. So the issues that we're going to touch directly impact the EU and its activities. So I looked through Antonia's presentation in advance, and I think it's very useful in better understanding general trends in Europe and around the world, and will be more informed about what we're going to do here in Russia. Ms. Trofimova, she's first vice president of Gazprom Bank. She's responsible for macroeconomic analysis. She's managing the rating consultancy center. Before Gazprom Bank, which she joined in 2011, Ekaterina Trofimova worked for a rating agency, Standard & Poor's, for 11 years in leading positions, and I think you had a chance to meet her at different meetings. I'm going to be the moderator of the first session. My name is Vladimir Chestyukhin. I'm Director of the Department of Financial Stability of the Bank of Russia. Now, Svetlana, it's your turn to present the remaining part of speakers. Dear colleagues, today we have structured our sessions in a very particular way. We split it into two major blocks. We will begin by the financial regulating block and the challenges in this speak. We'll speak about the Financial Stability Board and some options to resolve challenging global financial situations, and thus throwing a bridge onto some of the Russian efforts. In this respect, we're going to speak about the creation of the uniform regulator. And I'm going to present the speakers in my session without repetition, of course. I will represent two more participants, who are Vladimir Medvedev, head of the legal department. Andrei, sorry, he's my colleague from the Federal Service of Financial Regulation. And I think all the members of our session are professionals, and they're very well aware of what the Federal Service for Financial Markets is all about. And we have a great honor of having Sergei Butyrsky, Deputy Director of the Department of legal department, from the Board of Control and Oversight of the Financial Markets and Financial Organizations of the National Bank of the Republic of Kazakhstan. And the experience he is about to share with us is huge, and the idea of establishing this regulator was pronounced many years ago, and it's been in place for some years already. So it was first voiced back in 1998 and has been around for a long time. So I hope that Sergei will give us some of the important comments and tips as to what challenges await us, and he will share the achievements in this respect. And I'm sure the audience will be prepared to ask many questions and hope that we will be able to provide good answers to them. So let's get down to business, and I'm turning the floor over to my colleague. A few words by introduction. So the global financial crisis of 2007 and 8 called for unprecedented solutions and decisions to be taken both in political sphere and just financial markets control and oversight. And these decisions were taken in very condensed period of time because of the situations. The still topical question remains how good these decisions were, whether the directions for development were chosen correctly, and whether we can assess correctly the implications of these decisions, both for the development of economy of a single country, some countries, and the global economy at large. These decisions were taken at all levels, ranging from national state level onto the regional level, which is EU, and the global level. Such kind of groups as the G2 and as the Financial Stability Board came to play an important role, being responsible for taking some of the decisions. So I would like to turn the floor over to Svetlana Ichevskaya, who will look at the changes in the system of financial regulation that is underway in Russia. Svetlana, the floor is yours. Thank you very much, Vladimir. So let's look at what professionals on the financial market say about the financial crisis that has broken out. So we see, do we see reliable preventive measures and reliable instruments for quick exit when the crisis is already there? So almost all experts say in one voice we don't have any universal solutions. However, we have good recommendations and good conditions to develop them. All experts claim that the main reason is lack of financial regulation. We do understand that this is quite the general statement to make, lack of financial regulation. We can specify it more because almost all spheres are a little bit under-regulated, especially financial market is the most dynamically developing one. With its specific instruments. However, we can focus on some key specific issues that the financial crisis elucidated and which basically caused it to happen. So just financial instruments become more complicated while the norms of regulation trade are lacking. Dependence of financial markets on the assessment of the rating agency, lack of the control of the financial system in general, and lack of the system of monitoring of system risks and instruments and control over them. So the major premises basically enhanced the gap which was existent before the crisis, but the crisis showed how far away the markets and the regulators are, ranging from the technical issues of regulation to such simple issues like kind of funding the staff members that work in state bodies and need to develop important decisions to regulate financial markets. So there is a considerable professional gap and gap in understanding as well. And as a result, we have one of the most disastrous economic crises that hit the world back in 2008 and 2009. Another big problem that faced the international community, and this new problem that emerged after the crisis, the problem of the so-called too big to fail. So the bankruptcy of the financial institutes. So what the system of the state regulation can offer when such institutions are dying. So this is a great gap for the budget. What is more interesting for budget, to let them die or to save them? This is still a very topical issue, and I would be interested in knowing the opinions of the presenters. We know quite compelling stories of saving such structures, and no less compelling stories when the government let the structures die. So what are the implications for the budget of each of these decisions? My personal opinion, and I wouldn't even risk to tell what is better, what is more right, to save them or to let them go. I think the most important and effective way is preventive through regulation. This is the only effective way available. Like Vladimir said, all these problems that emerged and were brought about by the crisis involved like the Big 20 group and the Financial Stability Board that are working hard to prevent such disastrous consequences. So such institutions are consolidated and conglomerations appear. So we transcend onto the supranational level while the regulation is still happening at the national level. So the Financial Stability Board needs to provide guidelines and recommendations for the state national states who could apply it to their national regulation system to prevent financial systemic risks. I'm a little bit ahead of my presentation, so just the slide says what I has already covered. The Financial Stability Board has a lot of guidelines, over 20 of them, but I would focus on the key ones. So the standards in banking regulation and oversight, principles of regulating of oversight for the shadow sector, regulating and ordering of the derivatives, oversight of the systemic financial institution, reducing the influence of ratings on the decisions taken by economic agencies and others, which are over 20, like I said. The major of them have been listed, and I think it would be good to discuss them in more detail during this roundtable discussion. We can say that the Russian Federation, as a part of these international institutions, is also looking for ways to adapt and adjust these guidelines, because we're developing financial market and a developing economy. Country to national jurisdictions came up with an idea of a unified regulator, mega regulator, that will be tasked with certain functionality and will work to prevent such things that we saw during the recent crisis. I'm not going to speak about the mega regulator, unified regulator in detail. I'll do it a little bit later. So unifying institutes under one roof will ensure a more systemic approach, because control system is fragmented, so it reduces the potential effectiveness. So the urgency of reaction is the promptness is important, because those countries were more effective who were quick and fast to help their financial sector on the one hand, on the other hand tightened financial regulation in some other sectors. So uniting functions under one institution is for the better, is a benefit, as we think. So I'm a little bit ahead of my presentation once again. So this is what I just said. So my presentation is an introductory one. It's like some food for thought to trigger off a discussion. So I would like to listen to the comments of my colleagues, and Vladimir will set the time frame for the speakers and structure the proceedings. Thank you, Svetlana. I just wanted to add a couple of words to say that Russia this year has a unique chance from the point of view of regulation, because this is the year when Russia presides in the Big 20, when we are the country that forms the agenda, that prioritizes among issues, and there is clear interaction between different federal executive organs and the central bank to identify the top priorities. We do have time for one or two questions from the floor. As a moderator, I will start asking questions myself first. Svetlana, my question is to you first. Today, many legal acts are adopted. Many of them go through the Ministry of Finance. Then the normative acts and the bylaws have to be issued, and then the members of the markets who these acts are targeted at have to do some meaning making, how to apply them, and just to create their own internal procedures to internalize them. After 2000, do you think there was any time progress? Is there any good balance between the pace of the process and the quality of this process? How do you feel as an insider who sees a lot of documents going through your hands? Thank you. The pace has rocketed, almost as a space speed, and it is very difficult to ensure high quality with such pace. And we hope that we succeed in that. However, we are open for criticism and will take it. From the floor, we hope we provide proper quality. However, what market is allergic to is the recent reform of unifying two services, insurance oversight service and the Federal Service of for financial regulation. So the service is not under the Ministry of Finance. It is under the government. So in other words, structure-wise, it got a status that makes it independent from the Ministry of Finance. So there was a lot of disagreement between the body that determines the policy and the body that executes this policy, pursues it, and has to control the financial market. Hence, we're losing on quality, not due to the pace of the process of decision-making, but due to the fact that there is no coherent approval and coordination mechanism. Hence, I think the decision taken to create a unified mega regulator is absolutely right, because it will help us to overcome this challenge, regulating different bodies. The Ministry of Finance will hold the political part, and the central bank the financial regulation. we will be able to overcome the dispute and the conflict between these two major bodies. Hope I answered your question. So yes, your optimism is promising as well. Denis Rычkov, board of remember Force Group. Your presentation contained a slide about the decreasing influence of rating agencies and their opinion on decisions taken by financial bodies. I would like to get more clarity. Is there any differentiation in your approach between Russia-based and foreign-based rating agencies? Maybe there is a difference in their approaches. And the second question is whether it means reduced influence of rating agencies and reduced significance for financial markets as such, in your opinion. Thank you very much for your question. When we speak about the kind of decreased influence of rating agencies, we speak about it as a general goal that was set by the Financial Stability Board. The Russian Federation, as many other countries, basically rely upon the opinion of the world's leading rating agencies. My personal opinion, why we need to ensure the less influence, because of the conflict of interests. Back in 2008 and 2009, we saw just like absolutely irresponsible attitude of the rating agencies who were 100% risky in their activity. And of course, it calls for new mechanisms. Their reduced influence and impact can take different forms. We can take into account ratings and their opinions. There is no doubt that it cannot be changed. But we can change kind of the attitude to the benefit that is produced by their rating opinion. As soon as they lose the direct relationship connection between their rating and their the opinion, the results, it will reduce the number of provocations on the market. Thank you very much for your answers. But let's move on, dear colleagues.
A lot is happening on the Russian legal field nowadays, but even more changes are now implemented by our colleagues abroad. And it must be said, and I'll repeat myself, if for us it's the level of the national legislation and the level of international standards, that is the global, for them it's a triple level. If we take the European Union, some national rules are designed, then the rules on the level of the European Union, and also they have to take into consideration certain global recommendations or certain global standards recommended. In addition to that, if we consider different systems, Japanese or European or other national legal systems or the US, then we can see certain differences between the approaches towards similar issues. So how to coordinate all that? How not to allow this regulatory arbitrage? This is for Mr. Vicuña to cover.
Good afternoon. I will speak in English. My Russian is almost zero. I would like to have my presentation in the screen, if possible. Is it for me or is it? No. Very good. Yes. This one. Yes. Well, I would like to start by stating that banking regulation is a national domain. It has become more international only in the late 20th century, at the beginning of this century. Why? Because out of the bonanza of the late 80s and the 90s, there was a process of deregulation. Basically, in the United States, the abolition of the Glass-Steagall Act that impeded capital markets merging with normal banking. And secondly, also because of the abolition of the interstate banking prohibition. In Europe, in 1992, it was the prohibition of exchange control, so the total liberalization of capital movements. And that triggered a process of banks using all kinds of techniques, creating collateralized debt obligations, creating ABSs, asset-backed securities, by way of securitization of assets. It developed extraordinarily rapidly the derivatives markets, in particular the credit default swaps, which moved the risk around without accounting for them in the balance sheets. And all this created an internationalization of the financial markets, as well as a consolidation. There was a rush to have the right dimension in order to address these globalized markets. So there was a kind of race to have big banks by mergers, acquisitions, and consolidating all these by lines of business rather than by geographic repartitions. So this is one of the sources of the financial crisis, that all this process came without supervision and regulation being supranational. So there was not an international watchdog that could see the risks that were building, the imbalances that were building, and could not react to this. And this is the problem that we faced all around the world, how to address this issue of internationalized global financial markets in all directions with national supervision, with national regulation. And as the English expression says, it's very difficult now to renationalize this. Once the toothpaste is out of the tube, you cannot put it back into the tube. And this is, I think, the main problem that we face, and I want to addressing all the topics that I mentioned there. So what has been the regulatory response? What are the shortcomings of the response? And how can we improve the situation? Because the current architecture is not the correct one. So the regulatory response started in the Washington summit of the G20 in November 2008. And it was the first step by which it was demanded to have a global response to the financial crisis with proper regulatory approach that will be encompassing the several domains of the financial markets, but also the several markets themselves. So the first thing was to use the G10, to increase the G10 and to have a composition that will encompass also the main emerging economies. And that was the moment where Russia came into the G20. It was also a G20 that before it was focusing on general economy, basically north-south dialogue, investment, trade, things, into focusing into financial regulation, because that was the core of the problem at the time. Now, the main element of this construction was that the development of the Financial Stability Forum, a small club of the G10 that existed, that was developed to be the central point where all the supervisors of the relevant sectors of the market will meet and will have the strategic orientation, the policy orientations that should be given to the national legislators, regulators, in order to address the financial crisis. Also, not only setting the standards, but putting in place some mechanisms to ensure the compliance with these standards, so namely the reporting to the G20, the reporting to the IMF, entrusting to the IMF an enhancement of the surveillance processes under Article 4 of the Articles of Agreement of the Fund, that they make reports about financial stability of the countries. So this has been enhanced and reinforced so that this analysis should also examine compliance with the standards and the stability of the local financial system. In addition, there was a focus on reforming the IMF in particular because it showed too much imbalance in favor of the developed economies, so there was a need to give more weight into the internal institutional decision-making of the developing economies as well. And this is still a process which is ongoing. Now, the result of these decisions have been very positive. It was mentioned before that the FSB, the Financial Stability Board, has done up to 23 documents, reports about how to cater for all the problems that exist on the financial markets, in particular questions of the shadow banking, the questions of the remuneration and incentives in the bank managers and so on. So there is a list of things that have been developed by the Financial Stability Board, which I would qualify as a very positive. Here you see that one of the shortcomings is that we have now 4 bodies that address global financial regulation that have different compositions. Many of them are relatively matching each other, but there are differences as well, as you can see. So one, perhaps, of the first thing to do would be to try to have a proper consolidated body that has a consistent composition. Now, if we look now into the G20, the G20 is composed by 19 states plus the European Union that represent 90% of the total GNP of the globe. So it's a very important body. Now, what are the shortcomings of the G20? First is that it is just a group, it's a club. It's nothing established properly. It has no legal basis. It has intermittent meetings. It meets once a year. At the beginning, in 2009, 2010, 2011, it met twice a year, but then it was decided to have only one meeting per year. It has a rotating chair. This year it's Russia, but next year will be somebody else. Last year it was another one, Mexico. It rotates also the support teams, so there is a kind of lack of continuity as well. There is also lack of proper infrastructure in the sense that the Secretariat rotates with the chair. It has no rule-making capacity, the G20. It produces statements, communiques, but no real rule-making capacity, and does not have any power to enforce whatever is decided. There is also a lack of consistent membership between the G20 and the other bodies. I mentioned in the chart, in the slide before, that there is a core which is in all groups, but there is countries that are not exactly in one and the other group as well. Now, if we go to the other main groups, we see the Financial Stability Board. What is the legal nature of the Financial Stability Board? It is a Swiss civil law association. It's a private law construction. It is very important. It is a global regulator. One would like to have it as a global regulator, but it is a Swiss civil association. The decisions also are taken by consensus. What does it mean, consensus? It means sometimes unanimity. Perhaps it's not necessarily the unanimity, where there is a wide support to a certain measure, but in any event, it has the big defect that it goes always for the minimum common denominator. Instead of going to the best denominator, it goes to the minimum common denominator. It's also very much dependent. It is a very small secretariat, 20-something number of persons, so a very small secretariat. All are employees of the BIS, by the way, not of the FSB. It depends on the work of the 12 external standard-setting bodies that affect the world of finance. The decisions of the Financial Stability Board, first, they are not proper decisions, they are reports. They are recommendations, perhaps, but they are not proper decisions, and they are, of course, not binding. The IMF has been vested with a task to report non-compliance with the standards. The FSB cannot impose any sanction. There's only peer pressure around the table. They review the level of compliance, and perhaps one can feel the shame of not being compliant. It has a very small infrastructure. So it's a very weak body for the enormity of the task it has to address. And something similar happens with the Basel Committee, the Basel Committee of Bank Supervisors. It has no legal status. It has no capacity to adopt decisions. It is based on consensus. It overlaps with the FSB, and also it depends on the BIS. So there are very small legal constructions for the enormity of the task, and this is where I thought that the picture of the coolie there was a representative of what we are addressing in this occasion. Other shortcomings is that whatever is decided at global level, it requires national implementation. And national laws are very different. The reports of the FSB, of the Basel Committee, are compromise reports, so minimum common denominator, and then every country does whatever it feels necessary to do. So the national laws differ among themselves, and in some occasions even substantially, but of course in the detail, and also in the timing. Normally, the report of the Financial Stability Board would say this has to be implemented, let's say, until 2018, but then comes the date, and the date is not implemented in the major jurisdictions. On the supervisory side, we can see that the current structure of cooperation among supervisors is based on a very soft instrument called the Memoranda of Understanding. And this Memoranda of Understanding, being soft, in times of crisis, they do not work. And this is a reality that has been proven in Europe, in the European Union, in the case, for instance, of the two Belgian banks, Dexia and Fortis, which were partly operating as well in France and Luxembourg, and they did not share the information, they did not cooperate, and at the end, they had to have splits. The same with the ABN AMRO, as you will remember, it was also split in several entities, so the cooperation there also was missing. So there are also different legislations about what is the information that can be shared and what are the duties of confidentiality, and this also makes a break in the sharing of information among the supervisors. The jurisdiction, if you have to go to court, there is no international financial court, you have to go to national courts. And national courts tend to be nationally biased, they protect their own system, they protect their own system of law, they protect also the national interest, the fiscal backstops. So we have seen this in the several crises. We have seen this in the Lehman crisis, for instance, where the New York courts and the British courts have defended their own systems, and where the courts being affected with the insolvency of Lehman in the several jurisdictions. In Europe itself, we had 18 insolvency proceedings on subsidiaries of Lehman, and they had no access to information. They could not even have locus standi in the local insolvency proceedings in London or in New York. In New York, you face also the ring-fencing of assets that it is in the New York insolvency legislation. So you have a discrimination clearly against the foreign creditors. So all this is hampering a proper functioning of the global financial system. Global financial players cannot play with fragmented national legal frameworks. And we are speaking about those banks that in the 90s and the beginning of the 20th century were developed into global institutions that had all kinds of subsidiaries and branches all around the world, and they have now to play with all this fragmented situation. Now, these are some examples of these shortcomings. Capital requirements, Basel II, decided with all kind of pomp and publicity to be implemented by 2007. Of course, the crisis came, and it came without the United States having implemented the Basel II. Russia did not implement it either. So you had a collection of countries that did not implement Basel II, not even Basel II-5, which was an enhanced arrangement. Basel III, which was decided recently, 2010, has to be implemented by 2013. Now it is done, according to the FSB, only by 14 countries, and the EU has not yet implemented it, the US has not implemented it. So if you are a global bank, what do you do with this? If you have operations in the United States, you have operations in Russia, you have operations in Europe, what do you do? The same for accounting. The accounting world is a mess. You have the US GAAP for all kinds of American businesses. You have the international financial standards for a big part of the world, but even that, it allows for diversity in the implementation, and in particular, the banking sector normally has specified rules for accounting. different from country to country. Now put yourself in the seat of a managing director of a global bank. What do you do with this? How do you consolidate? Do you present different reporting to the different supervisors? It's a mess. We go to the bank structure. You will have heard about the Volcker Rule, which is in the Dodd-Frank Act in the United States, a big regulatory reform that imposes separation between capital markets and normal banking. It's a kind of return to the Glass-Steagall situation. Now, the Volcker Rule was about not mixing the two kinds of business with temptations to unethical behavior. Now, in Europe, we had the Liikanen report. We had in London the Vickers report. The Liikanen report says you have to segregate within the same institution the trading book. In the Vickers review, you have to segregate the deposit taking. So it's internal separation, but also you can see within Europe differences of view. Who is going to harmonize this globally? If you are a global bank, what do you do? Do you attend the Dodd-Frank Act, the Volcker Rule? Do you apply the British one? Do you apply the Liikanen one? And then, of course, if you have different legislators, you have overlaps, you have also extraterritorial applications. You see this in the over-the-counter derivatives rules that the Americans are imposing on all counterparts to American counterparts to register in the United States, to apply the rules of the United States, even if you are located in Russia or wherever. Now, how can this be improved? So first thing will be to change from soft law to hard law. It makes the decision taking more difficult, that's clear, but the result is legal certainty. You know what is the process to be followed. You have publicity of the rules, because one of the shortcomings of these committees is that they work in a very intransparent manner. Suddenly there is a press statement saying we have agreed on Basel III. But before, you know nothing about what is the position of the United States, you don't know what is the position of other players, etc., etc. So you obtain publicity. And also you obtain some basic legal principles which have to be respected. For instance, the non-discrimination, that you are a creditor based outside your jurisdiction, you should not be prejudiced. You have the same title against the same insolvent bank as if you were a domestic creditor. Ring fencing, in my view, is an illicit discrimination that should not be permitted. For instance, proportionality, subsidiarity, that you should not regulate whatever needs not being regulated, etc. Representativity as well. Nobody knows who is the one that makes these rules. They are officials, they are technocrats. I think the governments have to take responsibility. These are elected officials, and therefore they should be upgraded to be at the governmental level. And secondly, you cannot have regulation of the financial industry without speaking with the financial industry. So there should be a structured way by which you dialogue with the banking industry before you adopt these very important pieces of legislation. You need also to have very clear who is competent for what. Is now the Basel Committee? Is the Financial Stability Board? Is it the European Union? I don't know. I mean, there are a need to be very clear about who is competent for one. Then also the membership rules. You have seen that there is a diversity in the detail of the composition of all these groupings. I think there should be a certain clarity. And then the output, which should be, as I mentioned, hard law. What is the kind of hard law which will be possible? And here I put the example of the EU directive as a model instrument. The EU directive is a binding instrument, but binds to the member states to implement the directive. And then it leaves to the member states the ways and means to implement the directive. But you have very clearly framework, which is binding, of what should be done at national level. So perhaps something similar could be the instrument to be used for a global regulator. You have to choose the institution that should be the global regulator. Let me mention that there was a report of the United Nations in 2009 that argued in favor of a United Nations body, a kind of security council for finance, that will have the legitimacy of being for the whole United Nations membership. I think the FSB composition works well, so I think perhaps the best thing to do is to reinforce the Financial Stability Board. I have seen that the proposal of the Russian presidency for the G20 meeting in September is indeed to go into that direction, to foster the institutionalization of the Financial Stability Board, and I think this is a very, very sound move. It cannot be a Swiss private law association, it has to be an international organization for which thing you need to have a treaty. It is again cumbersome, I agree, but it is a solid legal basis for having a regulator, a global regulator. So you have to adapt the FSB to the task, and I suggest here, for instance, to avoid the consensus approach, which goes to the minimum common denominator, and to go into the same direction as the IMF, to have a qualified majority voting with a high percentage of votes, but that will be it. Nobody can block it. This is what could be a proper organogram, a plenary at governmental level, the board as it is today at regulatory level, regulators level, and then you should have interaction with regional groups in order to outreach to all the jurisdictions of the globe. You should have dialogue with the banking industry as well. And then, of course, you may have a secretariat, which should be a little bit more reinforced of what it is today. So the elements of improvements are hard law for which topics? I've listed what I consider to be the core of the banking system that should be harmonized all around: accounting, audit, solvency, liquidity, resolution, governance, structure, the question of dividing or not the trading versus the deposit taking. Soft competences could be the existing ones, but of course perhaps a little bit enhanced as well. Now, the final thing is about the jurisdiction. I think playing with national courts is always very difficult. So we can see that the financial industry has been moving towards having arbitration schemes. These arbitration schemes favor quick, expert resolution of conflicts, but this is very fragmented, it is very expensive. So why not to think of a court jurisdiction that will be the one interpreting the acts adopted by the Financial Stability Board, and also that could be the forum that global banks may choose for their operations global-wise, and it will provide for an expert court with a consistency of criteria. So if you have to interpret, I don't know, pari passu clauses as it exists today, we have the Americans' view of what is pari passu, we have the Belgian view of what is pari passu, and we have the London view of what is pari passu. This is a nonsense for a global player, so it will be very interesting to have a place that will have a good jurisprudence, an expert jurisprudence that would set a global interpretation of all these kind of global contracts and global regulation. And this is it. Perhaps I've been a little bit too long, but the topic was complex.
Yeah, Antonio, thank you very much. It was very useful and interesting presentation. But I have two questions for you. Could you take one?
Yes, of course.
The first question is about the following. Currently in EU, there is an ongoing discussion about how to build this new architecture of supervision. Who is going to supervise the participants of the financial market, whether it will be European Central Bank or whether certain competences will be kept by the national supervisory bodies. What we can see from the open sources tells us that the parties are inclined to agree that European Central Bank, EU Central Bank would perform this supervision on the supranational level, while national bodies would retain some of their competences in relation to small size and medium size institutions. But what balance deems most appropriate to you, in your view? And can supranational body provide adequate level of supervision? I mean resources first and foremost.
Of course, I mean, centralizing the supervision in the euro area is already a big challenge. This I fully agree. The regulation that has been approved by the ECOFIN, it is still, final approval is still pending because it depends on parliamentary clearances. It will be done probably in the first half of July. But it provides for 2 levels of supervision. One is the direct supervision by the ECB that will apply only to major banks, and we have calculated around the figure of 130 major banking groups out of the 6,000 credit institutions that exist in Europe. So in terms of numbers, the bulk of the institutions will still be supervised at national level. So for the first group, we will have all the competences that today exist for the national supervisors, except for several domains like consumer protection or anti-terrorist financing, money laundering, and so on. But everything that relates to solvency and liquidity will be in the ECB's responsibility, with the same powers as exist today. And there will be the national supervisors' direct supervision on the non-significant institutions, but under a framework that we will be able to define. So we have been given the regulatory capacity to regulate how supervision will be done by the national supervisors, and also with the power to say, on this specific institution, we want to supervise directly, because we feel it is not properly done, there is a national bias, or there is a systemic risk. So we can decide that specific institutions could be brought to the direct supervision of the ECB. Now, in terms of resources, it means basically a duplication of what it is the ECB today, and it will have also to intensify the relationship with the local supervisors, because, of course, the decisions will be taken at centralized ECB level, but, of course, there is a lot of groundwork to be done, and for this, the national supervisors will do it for us. And there is an article that provides for the basics of what is this cooperation between the national supervisors and the ECB for the direct supervision that we have to develop into what we call internally a framework regulation. And this framework regulation will be a long one, a detailed one, 100 articles or so, that will specify for every task how is the relationship between the ECB and the national supervisors. But it will be a system approach whilst the decisions will be kept at the centralized level.
Mm-hmm. Thank you. And the second question. Я заранее прошу прощения.
I apologize in advance because it can sound like a provocative question, but I'm interested in the legal component of this issue. It's about the bail-in mechanism. So what is your opinion? What is that? So when during restructuring or bankruptcy or during restructuration of some financial institutes, what if this bail-in system would include the requirements of senior creditors or even depositors? How do you think that it is possible to restore the stability of a financial institute at the cost of investors? Because we have some precedent in Cyprus, but I don't want you to speak about that. But your overall general approach, what is your attitude towards this bail-in solution?
Directive which is about being adopted, which regulates the bailing in, and that will be, I would say, the parameters for the future. Now, absent of this directive having been adopted and even more having been implemented, it is national laws that have government laws that have addressed the bailing in of insolvent institutions. Now we had several cases. I mean, we had the case of Greece, the case of Ireland, the case of Portugal, where there were national laws adopted that regulated how to address the insolvency of banks. And in these 3 cases, very clearly, they adopted the same parameters of having first the shareholders, then the subordinate and hybrid stakeholders, and then the senior bondholders, and never the depositors.
Never.
In these 3 cases, no depositors foreseen. Now, in the case of Cyprus, the thing changed because of the structure of the Cypriot banking system. We, since the beginning, thought that the insured depositors should, by all means, be protected, because by not protecting them, the state will have to pay out of the deposit insurance scheme. So in any event, it will be a task for the state to supplement the lack of, because the Deposit Guarantee Directive says that one of the triggers of the payment to the depositors is any administrative measures that impedes the bank to give back 100% of the depositors. And these depositors are covered until 100,000 euros per person and per account. So we always thought that this is an untouchable level. So above that, it was the separate legislation that decided to go for the bailing in of the non-insured depositors. And this is still ongoing because the calculations have to be still refined. The future is debated now. The crucial point that impedes the adoption of this directive is whether or not to provide depositors' preference in the directive. The view of the ECB, as publicized, we have an opinion in the official journal that basically says that we are in favor of depositors' preference because it protects the deposit guarantee schemes, so you don't need that they are fully funded or not fully funded. They will be the first to get the money back if they subrogate in the position of the depositors. So we are in favor of this because of that only, but also because of the consistency with the depositors' guarantee or insurance that prevails in Europe. Now there are some jurisdictions that feel that depositors and bondholders should be treated equally. We believe that bondholders are investors. They are protected by the capital markets legislation. They have a prospectus, they have a transparency, they are protected by the Market Abuse Directive. Depositors are not investors. Depositors, you may have an amount in the bank out of a payment that you have to do or out of an investment you have to do. So it cannot be that just by the chance of the moment of insolvency, you have to bail in more than the other one. So the deposits is something which, in my view, cannot be assimilated by any means to bonds, to normal bonds, senior bonds. So in our view also there are ontological reasons why you have to protect the deposits in comparison with the bondholders.
Спасибо большое за ответ. Вот, вы знаете...
Thank you very much for your reply. Dear colleagues, I would like to note that we often complain about our legislation, saying that it yields into Western legislation. But when you start discussing innovations like this latter one, sometimes lagging behind is good because it gives us a time lag to discuss issues in depth, taking into consideration European experience, world experience. So the level of ideas, certain initiatives seem to be very progressive, but on the level of their implementation, they prove to be not. So thank you again. So we've considered the issues of the financial regulation reform and how it impacts the market participants. We discussed how architecture changes on both national and supranational level, but there is one more very important issue. It's how the tightening of regulation impacts economy, especially in the sense that it is not occurring on itself, but economic paradigm changes. And now we have examples of huge monetary support that wouldn't have been possible 3 or 4 years ago. And now I'd like to give the floor to Ekaterina Trofimova, and she'll speak about the risks, emerging risks, and what to do with them.
Thank you very much. I have prepared some slides, but I would like to start by a general introduction. I would like to reflect a little bit whether we have much regulation or little regulation, because what we are talking about finally boils down to this issue, whether we have much or little regulation is related to the flexibility of human memory and its so I have a decades-long professional career, but even during my quite modest time, I do remember very well that some time ago, deregulation and liberalization of the markets was thought, and it was a consensus opinion, basis for thriving and recommended model to follow, and just prerequisite of success. Now we are moving towards tightening of supervision, which is a different extreme. So we're kind of balancing on a board. The truth is somewhere in between. And answering the question whether have little or much regulation does not exist. Because the answer depends on the extent to which we meet the market's expectation, how well we meet the expectations of the market. And so this board balancing, if there is a bias through either softening or tightening, so this entity will remain on the board. So it's kind of there are no specific numbers or statistic, and everything that is happening is resembles very much shaman's kind of worshipping, because financial markets depend on the trust level. Financial markets are an empirical creature, and I'm not analyst anymore, but I used to be for a long time, and I was to be awarded as a bank analyst, and it was a very pleasant news because I stopped this activity a long time ago. It was very pleasant. I worked in bank as bank analyst for a long time, and I analyzed, did my analysis during the global crisis and across the world. So I can say that once I discussed things with a very experienced corporate analyst who looked at the balance sheet and said that it's a default-prone company. It's a company that cannot exist. And I said, this is a AAA bank. So banks rely on trust. And now, speaking from the banking business, I should probably advocate that there should be less regulating, because less regulating in a very simplified way will increase the banking income. But I'm not going to lobby this position. I think that bank regulation should meet the expectations of the market and should restore faith and trust, because for banks it's the essence of their business. Because if there is no trust, it will bring us back to autumn 2008. It was very funny then to see such comments as, I think it was the UK regulator who said, yes, what happened, we knew about it. But the probability, perceived probability, was equal to the Martians landing. We do function here on the markets where all the probabilities are higher than Martians landing on planet Earth. So something that we already tested on our experience is an important asset for survival, some kind of practical experience. Such a view explains why the concept was very soon forgotten. The concept that was debated by the regulator and by the market as the counter-cyclic regulation. So this term was never used, but in the beginning we recognized that we needed to tighten regulation in good times, but now in bad times we need to relax it. But if you stand such this counter-cyclic management does not work in banking. So now if we soften regulation, it's not what the economic entities expect. And following your provocative question line, in my practice, in my time with the rating agency, I had a chance to see the regulating system at different markets, and I came to a lamentable conclusion that regulation does not provide a full guarantee of 100% risk-free strategy. It can reduce risks, but not fully stop them. So these are new rules of the game that are introduced that can carry on some additional risks. So for us as a bank structure, it is important to understand what's going on. So for me, regulating is a macroeconomic and managerial issue. And we think we cannot view regulating as just a legal basis and its direct impact on the situation with a specific bank or specific client or a specific market. It's an important element that should be analyzed together with some other factors and the activities that the state is undertaking and monetary policy including. And very often there is no agreement or even good understanding of how one or another step will impact the situation taken together. So in my presentation, I focused on a statement that is made into a title, tightening of regulation. And I'm speaking about the international, the world situation first and foremost, because the major uncertainty and risk factor for Russian members of the market are external ones. Hence, we're so closely looking at what is happening outside Russia, and Russia follows some models that were adopted on the developed markets previously. But we see that the situation in the West, if viewed in an integrated way, just leads to grave, serious risks of market deformations. And as Bernanke and other regulators began to talk about, so there was a kind of quite a helpless cry. So the risks are growing. Be responsible, but he doles out monies with his other hand at the same time. Before I show some of the slides to illustrate my thought, I would also like to say a few words about regulating and the foundations that underlie it. So I'm saying this for the very first time, so I would like to encourage you to think about such a topic. If, to be 100% honest, there are very few judicial, just legal norms or just state decisions that would be based on some specific scientific evidence or proof. Let me explain what I mean. Those from the audience who deal with the banks, and just now we speak about Basel III, but I suggest that we move on from Basel I. And I was asking myself why the capital norm was determined by Basel I at 8%, and I asked people in the West and in Asia, and using the snatches of the comments like anecdotal evidence, I found out that there is no scientific basis or scientific calculations behind this 8% standard. Why am I talking about Basel I? Because it's just they took capital, they just divided by assets, they didn't weigh anything and just checked it against 8%. There is a kind of some anecdotal evidence. I don't know whether it is true or not, so if there is someone who will prove it to be true, I'll give them a bottle of champagne in reward. So the story which I was repeatedly told, that it was a rule of thumb exercise for one practical reason, because it was a protective measure lobbied by the American banks to prohibit Japanese banks to enter their market, because they would never match 8% standard. Though the reason tells us that this prudential percentage should have been calculated basing on the statistically significant historic data with great distribution. Says that it'll either increase the problem data or just default potential. So all the there is a banking lobby, and this is a question of who wins over whom, because Spanish banks that fund themselves by covered bonds. This is a simpler form of securitization. It's less risky. So the Spanish succeeded in lobbying some covenants because otherwise they wouldn't have kept afloat. So it's for me it's like shaman kind of witching exercise, which is very seldom, if ever, substantiated scientifically. So speaking with professionals, it is difficult to just claim that it brings about the principal solution. But things like risk management that affect certain culture, not just calculating numbers, I think it is more important. And it is man in human in bank business determines how risky is that this organization. So it is difficult for me to understand how it is to be done. So there was a dispute. I think the banking legislation and financial markets regulation will approach such a situation as well. In the United States, in Europe, there is a conceptual crisis pending. So economy, is it good or bad? You might know that some of the politicians, many of the politicians, used scientific research by Reinhardt and Rogoff as a justification of the fact that too much debts are bad for growth, because they did some computations and as they achieved a certain correlation numbers, but later it turned out that they made a mistake. However, it was a scientific effort to calculate it. But in banking sphere, it is the situation is much worse. I analyzed data. We do a lot to struggle for capitalization, but if we were to increase capital as a measure to decrease the default probability of these organizations, you'll be surprised to find out that the extent of the correlation between the capitalization and default extent becomes statistically significant only at very, very low levels of capitalization, when you can see with the naked eye that this is a pre-default situation. Lehman Brothers, before they faced the default, raised their capital, capitalized quite high, but it never helped them. I fully believe that if we were to struggle for liquidity, but you should probably not be telling it in detail to the markets. If we want to combat the default risk, we need to regulate liquidity, but it's a mammoth job. It's extremely difficult. So let's struggle for mammoth, for Basel IV and others, if it'll increase trust. I'm not usually sharing liquidity regulation idea with general public. So these were some of the major thoughts behind my presentation. So tightening regulation is one of the factors of the dramatic decrease of trans-border flows of capital. So macroeconomic implications were a question about posed by the moderator. So by tightening regulation, some of the banks do not go to the market to borrow it for financial reasons. For example, Deutsche Bank claimed that they were fine, they were okay with capitalization, but finally they had to admit, and because it's commercially unprofitable, so the bank's balances continued to go down. And our central bank colleague will correct me if I'm wrong. So Basel III would be introduced in 2017 or something. Quite recently, I saw that all the major banks were confident that they will report about the full implementation a lot time ahead, and answering the question, why are you so anxious to do it faster? They think that there will be Basel V, 29 and so on, so why wait? So what sometimes vanishes from view is that the trans-border capital flows decreased, and it was not only due to the lack of regulating. So going back to liquidity issue, I think regulators are doing right when they try to bring liquidity back to the national borders. You might know about the liquidation of Lehman Brothers assets. So one of the problems there was that the bank had the practice to return all the liquid remains, refer them to the balance, some regional balance, and a lot of real money precipitated in the UK, and American courts cannot claim these monies because it's a complicated and long time process. So without trans-border capital flow, you cannot do it. And there are some other challenges. 2.5 years ago, Austrian Central Bank introduced a requirement, so they did not they introduced a certain ratio between credit and deposits. So in other words, they prohibited the subsidiary banks of its banks to just increase their activity through funding the parent companies and encourage them to raise money at local markets, which was very bad for banks and in Russia as well. So banks give back money to the local markets, and banks and others begin locked in their national borders, which aggravates economic crisis, and the banks are also returning money and assets to local markets. So deformation of the markets comes from major countries. I'm not speaking about Japan. It'll take another 4 hours to cover. So the Japanese situation might unfold to a great surprise, because it's a great experiment that we're all witnessing now. Whether we will be unhappy or happy participants indirectly, time will show. But the rates, especially with excess liquidity in the United States and the inflation rate that is not accelerating despite all concerns, so the rates of US bonds become positive after 20 years' time only. I'm not going to reflect on why. So the slides disappeared. Can you bring them back? Yes, they're back now. So we were always scared in a pre-crisis time, because we think about many things differently after the crisis, so we had to revisit many things. So many of you use such terms as Russia was always reproached that the credit to GDP ratios are very low, hence we're so underdeveloped, and in the West they have 120, 300 and 400%, so they're doing good. But then I also then said that it depends on what you want to achieve. It speaks not only of the level of development of the country, but also to the kind of a loan burden. So they designed not to default organizations in the West. And this kind of a long recovery with huge debts is something what awaits us for the years to come. As to corporate bonds rates, in real terms, they're negative. In the speculative borrowers attracting is the lowest ever, 5% only. So this is speculative securities. So Bernanke says things that sound right, but we need to do something about it. And these are the following slides that cover this. Bernanke already acknowledged it. So the monetary stimulus create conditions for ignoring risk. So the extent of cynicism is really funny, because we are tightening the regulation and prohibiting by one hand and creating permissive situation and conditions by the other hand. So you can tighten and toughen to an extent you find fit. However, risks arise in a different domain. In terms of the schedules, Peter Brass and other, not only the developed market are applicable, but developing. So the interest risk is great. So Peter Brass issued the record-breaking bond into the developing markets. So the share, the GDP share that was invested by the federal system up to 85 billion US dollars obligations are being bought by the Federal Reserve System, so it's at historical maximum. So the borrowings are growing, and the interest rates being negative can only move upward. So the question is when they will start doing it. So it all creates great losses, risk of losses in bonds. I just have one more slide to go, and then conclusions. So excess monetary supply results in the market's divergency, thus neutralizing, just abolishing ties between economic growth and the dynamic of markets. S&P's record-breaking, nickel was about 60% more. American companies' incomes are at historical maximum. A lot of liquidity is awash, but people feel sad still, and does not look good. So the second chart is the liquidity share in borrowings. So formally, the situation is encouraging, but the liquidity that was invested in state bonds, in corporations with non-investment rating, result in what is the last slide says monetary powers made so that the market is not competing for the resource by offering the excess liquidity. There are conditions created for ignoring risks, and in the conditions of changing regulatory environment, the market members are interested in finding faster exit from investments, and in direct loaning, such offers are limited. So in Basel III, the investments are focused in trade instruments, and the situation in which ultra-soft monetary policy pushes the markets through the sector of risk securities and so on. So what I was basically driving at is that in the conditions of macroeconomic growth, so there is a discussion that is taking shape. So after the September elections in Germany, it will get into a more practical domain, and we're approaching a more dramatic review of how the international world economic system developed in the last 3 to 4 years. So we'll find out whether we overused this kind of balance on the board, and whether we need to move in a different direction. Thank you very much for your interesting presentation and the food for thought. So we're almost exhausted our time frame, but I want to ask 2 questions.
Question 1. Here you mentioned some trend, lower dependence on external ratings. As a person who has experience of working within ratings agencies and in the banking community, currently or in the nearest future, is there any real alternative to rating agencies? And my second blitz question is, you touched upon the impact of regulatory measures onto the economic growth, and you mentioned Basel III, but from the point of view of a banker, Basel III, from the point of view of capital, Perhaps it will be introduced as of the beginning of next year, but as for liquidity, it will be 2015. Your preliminary estimations, what do they say? Introduction of these regulatory measures, will it impact significantly the capacity of banks to give credits, give loans, or will it result in slowing down the economic growth because of less credit loans being given out? So my blitz answers to your second question: yes, a little bit, insignificantly. Yes, but it was very brief indeed. And briefly answering question one will be, it will take longer. The ratings will continue playing an important role, a growing role, until the markets begin operating with growing amounts of assets, and until human nature won't change. People tend to want to lay the burden over to somebody else to make decisions. People don't like making decisions themselves. Dear colleagues, are there any more questions to the participants of session 1? Yes, please. I want to thank you, Katerina, for your wonderful presentation. It was quite memorable, at least for myself. In our legal environment, we have to operate not only with graphs and diagrams, even though we have to do that, especially as of late, but also we have to think within certain frameworks when we work with business. But if I understood you correctly, you expressed hidden criticism of the trend existing on the level of Basel Committee and global regulation, the G8, G20 level, then FSB, and all that. In your view, is it because international infrastructures are shaped inadequately? Is it because of their architecture? Or is it because they're oriented towards national priorities? Or maybe there is some kind of reserve, and maybe those bodies will prove capable to meet new challenges, see new risks, the risks that are yet invisible even to the market participants. Thank you. If I understood your question correctly, the existing international structures, well, what were you asking about? No, well, you, as it seemed to me, you said that the mechanisms that are now suggested by Basel III and so on, it's not an adequate response to the challenges that have emerged. Then you began with Basel I. You traced the historic trend. Do you think that they're doing the wrong thing or what? Well, now I understand why it was so difficult for me to understand your question, because it is very difficult to give the answer. There is no objective criterion. In the very beginning of my presentation, I said that the rule of thumb is the main methodology here. What markets will like and what they won't like. There is no ideal structure or model structure. It depends on how things work out. I'm not in favor of, well, yes, of course, there are some shortcomings in the work of regulators. But if we substitute them for some others, it doesn't mean that we will immediately get an ideal structure. I'm a great supporter of all the mechanisms that restore trust. This is what they do in Europe, in the US, and partially in Russia. Whether this is always done in the optimal way, I'm not sure. But I do not know any better way. So what I might offer, or Vasya or Peter might offer, that would be also some only options. And there is uncertainty about the response of the market to the mechanisms introduced. So whether you are a great speaker or a bad speaker, you don't know. When you walk out to address the audience, before you begin, you don't know how it can go. So I just deal with behavior finance, financial behaviors, and it's a very soft and abstract area. When you read the report where esteemed banker, analyst, writes the markets dropped because in the morning such and such had blue eye or some bags under the eyes, it doesn't matter. So no comment. This is unscientific approach. So also the plea of my soul. We are now discussing investments into infrastructure and how important it is to improve networks of this and that. And we often forget about such things as infrastructure, communication, image building, expectations management, and very often little attention is given to these areas, and they are extremely important. And it is for scholars to work out, because it's really maybe not less important than other efforts undertaken by the government, but it's a different area, and I don't want to waste your time. Dear colleagues, Roxipshin Bank, Konstantin Rukakov. So I have an unpleasant question to ask. I don't feel like asking it, but since I want to know the answer, I have to ask. So I don't, why it is unpleasant, I don't know, because I don't know to whom I can address it, to my favorite Ministry of Finance or to Katerina or to whatever. The question isn't pleasant because it is really hanging in the air, but the answer will hang in the air as well, as it seems to me. So yes, now the rate of making new laws are growing and growing, and we're still coping with it. But I couldn't disagree with this more. I'm wondering what has happened. Why are we so quick in issuing new laws? What my comrade and colleague and friend, Mr. Guzov, so I said, I can see the visible hand of the Ministry of Finance here. He said, what makes you think so? Because I said, because I just didn't realize, see it. So the three last draft laws that were mentioned in April, why did we decide that speed will assure quality? If we think about the economic tools or mechanism there and others, with all my respect, of course you are a great professional, nothing personal, but I have no one else to ask. What has happened? Why this race? Well, some poor businessman does make some mistakes somewhere out there, and now he can't become a deputy or chairman of some regional bank to curate the issue. Why so? Why is it that we start just using different measures to minorities and majority? Why it is that Enadine is the ruling instrument, and the only tool we are now using is a very big whip. So, what's happening? This is a very simple question. You know what? I'm ready if you can support me, but I have everything. Well, first of all, thank you. It's very pleasant to answer the question, not about yourself, because you characterized me as a good professional and as a person you respect. So it's not about me. So that's why I feel really comfortable answering your question. But what I want to say is, you know, what's happening? It's not the right formulation. If something really happened 22 years ago and still is going on, then this question would be the right one. But I will try to tackle this technologically. But then I will probably arrive in the area of psychology. We've always been trying to catch up with someone. We started developing regulation when everybody started liberalization, then vice versa. So we only started liberalization when others started tightening regulation. Some did it 20 years ago, some 50 years ago, and then we tell ourselves, let's do it within 5 years. No, 5 years is too long, 1 year. And as a result, we have had several mini 5-year plans in this area. And as for this mega regulator or unified regulator of the financial market, we'll discuss it later. But this catching up process has some objective grounds underlying it. Russia is G20 member, FSB member, then member of quite a number of very serious organizations tackling financial regulation. You know, today our role within those organizations can't be very nice for our image, because the issues that are being discussed there, they are not beyond our understanding, but we have no practice with that, no experience, no practical experience. We have no tested approaches. But the crisis of 2008 leveled up Russia with some other countries, because many things there are also innovations, not only in, and so there are innovations not only in Russia but also elsewhere in the world. The crisis of 2007 and 8 happened, and then we didn't have enough time for kind of developing this. So then the race that started 20 years ago, for us it continues, and there is no end seen to that. And the second aspect, the aspect of psychology. Think, till recently, and a lot is changing in the mentality of our partners as well. If in the past we had 5-year plans, 7-year plans in Russia, now they also assume our paradigm. 5-year plan within 1 year, and so on. If you're with us, and just, you know, we all have ambitious plans in developing business. Maybe you do not set long-term goals, and you say half a year is ideal if we from 180th place come to the first. If it is 1 year, it's so-so. If it is a year and a half, then it's a failure. And so this kind of approach, this kind of psychology is ruling. But after 2007, this psychology is changing. And this is what I can say about the speed. But as for the quality, I would, well, evidently, I agree that it is very much a matter of speed, but also what we do, well, we have no practical experience to build on, and transplanting foreign experience onto the Russian soil doesn't yield very good results either. So, but responding to you, I can continue. Actually, banking industry can't brag with any good results in this, because just you suggest openly on the level of a project to banking partners to think, to make calculations, to analyze what Katerina was saying. Usually this suggestion is not met with enthusiasm. Some of them can do something driven by their enthusiasm, but when they see questionnaire from the ministry, 10 pages, 50 questions, are you crazy? We are not going to fill out this survey. Our balance doesn't balance, and we have more important issues to tackle. And then all the claims begin. All the claims begin when the act is already implemented. Then our subjects have to adjust their procedures and all that to this newly implemented act, then they see that there are gaps, that the old system is not compatible with the new one and all that, and then they start complaining. But there is one evident trend: globalization of regulation. Yes, it's a very difficult process. Yes, it will be a lengthy one, but it is moving forward. As Antonio said it perfectly, that means for us that with time, and I don't think that it's in a very distant future, but those rules which now have the name of soft laws or recommendations, they will become binding rules. And from the process of implementation, we'll pass over to the process of enforcement, and that will require from us on our national level, both on the part of private entities and on the part of the government, we should assume active position. We should be proactive without waiting till they are implemented on the global level. We must contribute on the stage of their development, which is what our British, German, and other colleagues are doing now. So if you attend some international forums, they assume very active positions and they defend their interests then, proactively, rather than complaining afterwards. As I have now realized, I'm the only person who tried to participate in this proactive process. I know that many banks were offered that, but I was nominated to participate in this European Banking Association or whatever. And you can't even imagine the level of surprise or even fear when, during discussion of a directive, the person with a Slavic tongue twister of a name starts making suggestions, and then they ask, where are you from? And they discover it's from Russia, and this person can write in English, and it was a shocking surprise for everyone. So from my personal experience, I wouldn't say that in global financial space and at the level of banking institutions, there is this readiness to perceive us Russians as equal partners in this exercise of building new laws or systems. This is my impression. So the speed, because we must move towards globalization, the speed requirement, that requirement to be proactive, well, actually, yes, this is true, but central bank, take central bank and how it would respond to that. So very often we do get those questioners. And now I want to defend the banking community. There must be some breaking point in our relationship. Central bank started sending out questioners. It's not a new thing, but central bank is beginning to listen to the suggestions of the bank. This is a breakthrough. This is a new stage. So hopefully it won't be just formal response in the future, but it will be something constructive and useful, and it serves the interests of the banks themselves and the government. And then there are such initiatives on financial markets, and we are actively involved in those. But it's a systemic problem. It's the problem of the system, because not every institute can really cope with that, because it means a lot of unpaid work. And banks are very often small organizations, and sometimes some of the questions require some in-depth research. Not all the banks can afford that. Dear colleagues, now we have absolutely no more time left. A brief comment from Svetlana and one question. Trying to save your time. Well, actually, we have a wonderful issue to discuss during session 2, and of course it will evoke not less interest on your part. And of course we have a lot of issues to discuss, because we are now witnessing the making of a new institute in Russia. Our legal system is not bad. Regulation is not bad. The problem is with enforcement. You said that patience, colleagues, patience. You were polite, yes, but okay, there are no problems with regulation. Regulation of good quality. A problem is with enforcement and implementation. As one of my colleagues says, pension is wonderful in this country. It's only too small. We have very good laws, but we have poor law enforcement. So let us now bring this discussion to closure, and this criticism was not in our address, and thank you for your support, really. And let us now pass over to the next issue. Well, I'm from the Higher School of Economics, Anton Silivanovsky. After you claim that regulation is wonderful, I am not sure that I can even dare opening my mouth. But a very brief comment first. Katerina kept speaking about trust, and she never said trust who, and trust financial institutes, that the government should trust financial institutes. And we forget about investors, clients, and the rest. And as for our legislation being beautiful and only enforcement having some shortcomings, as for this, so there are a lot of bad cases in like manipulations, conflict of interests, unfair conditions in financial markets. And yes, you all, as far as I understand, like this legislation. That means that there are no unfair conditions, no conflicts of interest, no nothing. But maybe as for this, well, maybe this is a bridge over to unified regulator. Colleagues, thank you very much for your comments. I think that Katerina mentioned universal trust, but this is oral history. So you tasted the pie and liked it, and now it has come to an end. So let us thank participants of session 1. And I'm giving the floor over to Svetlana for her to start session 2. Dear colleagues, we are now passing over to the theme of unified regulator. There was a just reproach that there is no regulation in certain spheres. Well, of course, you can't say that legislation is perfect if it is non-existent. So the quality of regulation issue, and it's really relevant when the market is developed. And the issue of unified regulator is an important topic. So here I'm thinking back to the beginning of 2000, when this need was first verbalized in Russia. And then certain research was commissioned to FKSB, and then they concluded that unified regulator would be premature. This was the position of 2000. The market being underdeveloped, such institutes as unified regulator would be immature. So we keep saying regulation is interrelated with the market. It can't exist autonomously or independently from the market. So if the market is underdeveloped, then unified regulator is inapplicable, because you can't follow the rules that are active in the US or UK in Russia. We must create our own institutes. So what about my presentation? Can you please put it on? And I need only a couple of slides. Because I'd like to begin and then give the floor over to my colleagues. apologize for this technical pause. Нету. Старое. So let's consider some of the prerequisites for the decision on building this unified regulator, and overlapping of competences and powers, and then some fragmentation and gaps between the functions of the government, and of course, universalization of financial institutes. Financial institutes growing larger, becoming more complex, creating new financial tools, and that means the need of some controlling body, regulating body to understand what is happening on the market. I think we all now realize, and it's not the problem of Russia only, everybody admits, that controlling bodies are always lagging behind the markets. A kind of refusal from the segment regulation, so this uniform regulation, monitoring of the financial system as a whole, less financial arbitrage and less supervision. Choosing the form and formed. So maybe the first issue to be discussed will be only about the law, the legal, because when we discuss financial and economic institutes, we always are on the edge between the finance and law. And this issue is about law and only jurisdiction. So when we were thinking about the form for the unified regulator in the Russian Federation, we immediately faced the following problems. It's delegating powers. We started discussing delegating certain responsibility to or financial body, ruling financial body, or some central bank, which formally is not part of the financial regulation system. But of course, central bank is. So the problem that many lawyers were doubtful about whether it is possible to delegate those powers to non-governmental institutions. It can be tackled by delegating to the central bank, and our system can cope with that. I can't see any major contradictions in it. Moreover, the Constitutional Court back in 2008 researched, investigated into this issue, and they recognized the possibility of delegating some of the government functions to a non-governmental institute if this agency is knowledgeable of the whole system. So the discussion about delegating powers came to its end on that stage. At least there's no ground for me to think that it's going to be continued. And the decision was made about delegating this function to the central bank, not as a separate body or autonomous body, because once it was a serious legal issue, because central banks simply cannot have this. Only those departments that do support services. So that's why we chose the category of structural subdivision of the Bank of Russia. And what we can see now in the roadmap and that was designed, and that periods of passing over the powers from ministry to the Bank of Russia, and the roadmap itself, they testify to the fact that the government now fully understands the route taken. I'm not even going to discuss this slide because I have extended presentation on this topic, but for the sake of our further discussion and for next speakers to think about, I'd like to raise some of the relevant questions. It's the criticism, the same as in the beginning of the 2000s. Is the market in Russia developed enough for the unified regulator. Then the possibility of the conflict of interests when the Bank of Russia assumes those new functions. Then what are the prerequisites for increasing economic efficiency and effectiveness? And what are the alternatives for further changes in the system for regulating Russian financial markets? Now the professional community has split. We have a lot of, well, actually the major part of professional community believes that this unified regulator now is still premature. So it is with my greatest pleasure that I'm giving the floor over to my colleague Vladimir, and I'm confident that we'll hear answers to most of my questions, and I hope that we'll continue this discussion with the audience.
Thank you very much, Svetlana. I'll try to begin. I don't have a presentation as such, so it's very good that you prepare this questions for discussions lists that will bear them in mind during this debate. But the theme of my presentation originally was devoted to the changes that should be introduced into the central bank law so that the unified regulation could start working effectively. But I will say a few words about the major goals behind this creation. 4 goals can be identified. Number 1 objective is to increase the effectiveness of supervision over the financial market members. When we speak about different groups and holdings and that bring together members of the financial market, so the Bank of Russia today cannot pride itself on great achievement in terms of the consolidated inspection and supervision, and especially with regard to groups and holdings that professional financial market members are part of. So one of the objectives behind creating of the unified regulator is to formally unify the Bank of Russia and just the Federal Service for Supervision for Financial Markets for more consolidated supervision and more effective effort. The other objective was to assess the financial stability. So while doing so in Russia, the central bank also analyzes the banking sector, also in terms of the outside effect on Russia, because banks are the major financial intermediaries on the market, and their functioning determines the health of the banking system at large, and also the major part of analytical information that the central bank gathers from loan-providing organizations, because it is their regulator and oversight body. So the Service of Financial Market Regulation does the same when they try to analyze various segments of financial markets. They have problems finding information about the function of the loan-giving organization. So this unified regulator will result in a single unified database, so the financial market will be analyzed as a whole, not in fragments. Thirdly, both for us and our international counterparts, it is important to remember that the central bank has a status, and which is set out in the federal law, the central bank, and in the constitution, which is quite unequivocal. It is independent in pursuing its policy and taking its decisions. And speaking of the functions performed by central banks, it does so quite independently from other bodies of state power. However, independence does not exclude interaction and cooperation. The central bank works in conjunction with the government of the Russian Federation, and many of the decisions, no matter what formal shape they take, is a product of interaction and cooperation between the central bank and the government. And the fourth objective was to increase the material base of the Federal Service for Financial Markets. It's the service that will become part of the central bank. So the Federal Service for Financial Markets is in great need of additional staff members, and possibly it will need better qualified staff members, which directly relates to the level of wages and the salaries that the staff members receive. And as it was a debate within the federal budget, it is difficult just to achieve it through the government monies only. So the central bank can increase just the funding available to provide more incentives. So last year, it was voiced that we seek to create a unified regulator on the basis of the Central Bank of Russia. It doesn't mean that this is an easy task. We are aware of the amount of challenges that we face. However, I will bring you back to the new things in the central bank law. One of the amendments will extend the third article that will add more objectives like development of financial markets and ensuring the stability of its functioning. It's a good example for the further interpretation of this norm. So the central bank repeatedly was reproached that it deals with risks, but is not targeting at developing financial markets. So now it was set out as an objective, as an overall goal. So development of financial market now has been registered as a priority of the central bank. It's not part of the risk-related regulation of the market members. So ensuring the stability of its functioning refers you to the financial stability functions as a result of the crunch of 2008 and 2009. There is a Department of Financial Stability within the central bank, and we have to ensure this alongside with the stability of the bank system. That will contribute to the financial stability of the market overall. We also have more functions in control and oversight for non-loan financial organizations, and we list them further in the law. So these are the regulations that are being pension funds, insurance companies, brokers, dealers, all the institutions that are under the jurisdiction of the Federal Service of Financial Markets. Also extended powers include the issues of accounting in exercise and oversight of the non-loan institutions. So they regulate credit organizations and their accounting, and the non-credit, non-loan are done by the Ministry of Finance. So thus the central bank will receive new competences and jurisdiction here. So maybe it will take years for us to create the creation of accounting for non-banking financial institutions, but we will nevertheless start the process. The Bank of Russia will also powers to ensure compliance of market manipulation and just abuse of insider information. We are at the very beginning of this long way, and this is what you mentioned during this discussion. We think that the Bank of Russia will do things in this regard, and just we already started recruiting new staff members for this department, just to cooperate with the Federal Service. Considering that the bank will have extended powers and functions as of the new law, so the board of directors that will now include 13 members will be extended to include 2 more, thus totaling 15. So it doesn't mean that the 2 new members will go there from this area, but basically each block delegated 2 directors to the board of directors. So just 2 more appearing as the ones that represent the block of regulating and supervision of non-bank financial market members. Another important body that is being set up is the board of bank supervision. It will be responsible for key issues of oversight on financial markets. Together with our Federal Service on Financial Markets colleagues, we discussed this. There is a certain specificity in its functionality. It may deal with a little bit different set of powers. However, so this Committee on Financial Supervision will play an important role in overseeing all the process in the financial markets. And another potential, it's a norm for self-regulating organization. Specific rights and obligations of a self-regulating organizations will be listed and set out in a special legislation, but these self-regulating organizations will be approved by the Committee on Financial Supervision, so they will probably have some of the oversight powers. There is a big discussion underway now, but this project is being designed. As to the law, I think we are quite clear now, so we shall move to the law enforcement area. There are 2 big challenges that the central bank should respond to in the nearest future. I think it's rather law enforcement domain that they refer to than the law itself. First, how to deal with the diversity of goals and objectives. So the central bank already had a number of objectives to take care of. So with the new additional ones appearing, it will get more work on its hand. So basically the chairman and the chairman of the board will have to prioritize, and it is important not to allow for disbalanced approach to achieving the goals. But I hope that this ongoing control and discussions with our colleagues from the Federal Service will prevent the situation. Not many new things in terms of the conflict of interest appear in the extended powers of the central bank, because already there is a potential conflict of interest. So there's a savings bank relationship. So there are some conflicts, but today we have tools to delimitate these conflicts and create a certain system of deterrence. So when we start regulating professional market members apart from the banks. The conflicts will be very similar. It will kind of probably enhance this conflict, like in the Moscow Stock Exchange. So we have a share in the capital of the Moscow Stock Exchange, and we'll now need to regulate it. So it's one of the examples. So I'll stop at that. So should there be any questions, I'd be ready to take them. Thank you very much. I'm sure that our audience has already been much clearer about where we're going in creating the unified regulator. It's important to understand the changes that are introduced into such legislation, because new laws so such major institutions can be either created through new laws or through amending the existing ones. So we decided to follow the latter scenario. In terms of the status of the central bank, it is not quite certain well, it is determined in the constitution and the law of the central bank, but there are some property issues and the shift of functionality issue. The public and there's the private functions. I'm not offering it for the discussion, but just for the future. Whether the state immunity covers the central bank when it is when it begins to carry out the state functions. So the it's the public legal relationships or others relationships make the status of the central bank a little bit ambiguous, because this has not been resolved at the level of the legislation, and extending the public functions of the bank, we extending the risks, so we need to be careful about it. So Sergei, who is the next to speak, will bring some new international touch to our experience. So it's on the one hand distant, on the other hand quite close. So I'm sure we'll hear a lot of interesting things, and we'll hope to have some recommendations from Sergei, and we also hope to share from some of the mistakes that we can avoid doing, from learning from his experience. I would like to greet all the participants of the forum. So I would like to greet you all on behalf of the National Bank of the Republic of Kazakhstan, and I would like to thank for the invitation to take part in the forum. I'll review the Kazakhstan experience of unified regulator of the financial market. So the financial market in Kazakhstan is not as large as that of Russia, and currently it includes 35 banks of the second tier, 37 insurance organizations, and 17 pension funds. But we're going to have a single pension fund from June this year. So this makes the financial market ready for reforms and regulation. And on the other hand, and establishing of the unified regulator, and on the other hand, you need to strike the balance of interest of the commercial structures, members of the market, to prevent the stagnation and over-regulation of the market. But during the first stages of acquiring sovereignty, so the interests of reforming the national financial sector called for a unified regulator of the financial institutions, relying on the best international practices. So we decided to go by evolutionary way. There was a staged process. Theoretical and organizational prerequisites were equally important. So the bank supervision was made by the national bank. So the insurance was by the Ministry of Finance, and the pensions, the Securities Commission, and the pension fund was part of the Ministry of the Social issues and so on. So it's a similar structure in the Russian Federation. Now, 15 years ago, we asked the Shakespearean question, to be or not to be, for the unified regulator, and voted for it finally. And we started creating it in 1998 when the Bank of Kazakhstan was delegated the insurance control functions. And so the functions of the securities supervision were channeled to the National Bank, and some other powers were redelegated. So thus, we, relying on the methodological information and practice, we reformed the regulating system. So by December 2003, all the functions of supervision and control and oversight of the financial market were under the brought together to the central bank, Bank of Kazakhstan, and the National Bank became the consolidating vehicle. So it was important that the National Bank, as a exercise the banking sector reform. We now have 37 banks. In Kazakhstan, they all have enough capitalization level, sufficient capitalization level. They meet the international standards and have good assessments and ratings. As far as I understand, in Russia currently there are over 1,000 banks of the second tier. And we had the same picture in Kazakhstan in the beginning of the 1990s after the conditions for them were toughened, so now we have only 37. So the unified regulator is not a mandatory element of any national supervision mechanism. This body characterizes a high development of the financial and regulatory system of this country. So the major prerequisites for the increased level of regulation became the unified regulator. So it became possible to have a single approach to regulating oversight, then carrying out effective monitoring of operations under the financial system, and just this sorting out the negative tendencies and providing for the urgency and flexibility, and promoting effective use of resources and others. So, we studied the regulating systems in many countries to model on. So the second half of the 20th century was marked by the integration of the bodies regulating financial markets. So the first to follow along this line were the many states of the Western Europe. The consolidation trends for financial markets also encompass Hungary, Mexico, Japan, South Korea, and Latvia. In some of the countries, consolidated oversight existed since the forming of the regulating systems, like in Bermuda, or the Isle of Man, and Uruguay. But the very first one in centralizing effort was Singapore back in 1970s. From 1914 to for 2004, the number of countries who went along the unified and centralized way were increased from 3 to 13 countries. There were specialist organs set up, so we decided to use the model of the British regulator for our unified regulator of Kazakhstan. In December 2003, we adopted a law on the state regulation of the financial market and financial institutions. So the new structure that brought together several levels of supervision was made into an independent agency that was accountable to the head of state. So, in accordance with the basic efficient principles of Basel board, all the supervision bodies have to have clearly set out powers. They have to be fully equipped to be prompt in their response and just have a legal environment ready and as material base. So the agency of regulating and oversight of the financial markets, insurance and pension funds and credit loan bureaus were set out. The major activity of the agency was to regulate and oversight the financial state of the financial institutions, to provide for the financial stability of financial markets and financial institutions, and increasing and maintaining trust to the financial system as such, to protect the interests of the consumers of financial services, creating equitable conditions for the financial organizations in order to promote fair competition principle. In doing so, the regulator had to set out the standards for their activity, just increase corporate governance, monitor financial markets in order to ensure the stability of the financial system, focusing on the most risk-prone sections and stimulating introduction of new advanced technologies that will provide full information about the activities of the financial institutions and their services. So the National Bank had a special status. It was the only central bank on the CIS territory, and it was focused on carrying out the functions attributed to the classical central bank. However, the issue of participation of the central bank in the activities of mega regulator was under debate still, and the issue of delimiting powers was resolved at the legislative level. So the National Bank has a major goal to provide the stability, price stability, and we developed and carried out the monetary and fiscal reform, provided for the payment systems, provided for regulation and oversight of the currency regulation and others. And to increase coordination and interaction and pursue an agreed policy on the financial market, so the chairman of the central bank who became the member of the board of the agency, and vice versa. The board of directors contained 7 people, chairman and deputy, and 1 representative from all institutions and 1 from the government. So there was more detailed information provided on a more regular basis about financial instability. That was important in order to provide for the effectiveness of the unified regulators' activities and the central bank's activities. In 2007, between the government, central bank, and an agency, there was a memorandum concluded on financial stability. Another important issue in the mechanism of creation of the unified regulator was its funding. There are many funding models available from membership of the central banks and the state budget. In order to retain well-qualified staff members and competitive salary provision and excluding of the conflict of interest, we chose the third option that was codified legally. So the parliament, the president and government have the legislative initiative prerogative in Kazakhstan. So in our practice, if the agency designed the draft of the law, so it discussed it with the members of the financial markets, then with the government, and then the government referred this draft to the parliament. So ratified by the parliament and signed by the president, the agency then designed and developed all the bylaws and legal norms. So we saw a lot of progress. In 2005, there was a law on consolidated supervision adopted that provided for the monitoring of financial state of major holdings, banks, and control of and compliance control. And there were conditions created for the development of infrastructure, financial market, and just also optimized license and permission procedures. We optimized the procedures of direct and distant control. It was risk-based, apart from checking regulatory accounting. So we also have field inspections in terms of risk management, corporate governance, and their effect on the status of the financial organizations. If the breaches are identified, the certain sanctions are taken. The memorandums of understanding are concluded with the financial regulators of other countries in terms of cooperation and increasing of interaction. And there is also an integrated system of protection of financial services consumer rights. So IMF ruled that the degree of compliance and the level of development in Kazakhstan was quite close to that of the East European countries. However, we need some amendments and corrections, so the financial stability can not only be provided due to the efforts of the financial regulator. So the monitoring and oversight bodies should work in concert to take into account both micro and macro risks and processes. The global financial crisis revealed the imperfection of the oversight, so it proved lacking in urgency and promptness and flexibility. So IMF in its analysis pointed out that the developers did not take into account the increased macroeconomic balance that augmented the system risk in the financial system due to the high prices on assets and the increased share of loans. In order to provide for more promptness and flexibility, the international community deems necessary to set up joint committees on high level to design policies to prevent system risks and provide for the financial stability. In 2007, in terms of the cross-sectoral coordination and effective development of the financial sector and stability, so we decided to set up the Financial Stability Board, so it helps to carry out macroprudential regulation and minimize systems risks. So the anti-crisis program and its successful implementation is a good example of successful prevention of systemic risks by increasing interaction and coordination between different government and market sectors. By increasing the effectiveness of central banks, we implemented important changes in control and supervision of financial organization. In 2001, the agency's powers were given back to the National Bank, and as the Committee on Control of the Financial Markets and Financial Bodies was established in 2012. Within the National Bank, there was another committee, a committee to protect the rights of the financial service consumers. In order to achieve good interaction between the bank and the government, so the chairman of the agency is member of the board of directors of the central bank. So the prerequisite for unified financial regulator is to first carry out financial reforms and ensure high level of development, and also delimitate the functions and set out objectives and provide for the adequate material basis that will be codified by relevant statutes. As to the stability and regulation, it is important to model on an effective model and just increase interaction between the relevant governmental bodies.
Like in Russia. Well, in Kazakhstan, we're pursuing a similar way in creating a unified regulator based on the central bank of the country. But we believe that in the future it will serve us right, because we're still moving in the same direction, and in long term we envisage uniform currency and creating integrated market. Thank you very much. Now I have a question to the audience. Are there any questions to the last speaker? So, Higher School of Economics, Professor Shishkov. I have a question about the change in the functions of the central bank. Right now, the Bank of Russia also supervises the situation with criminal revenues. As of January last year, there were some new laws about corruption adopted, and they envisage the companies creating a similar structure to that of OFT, like in the banks. Well, they appoint a person responsible for this area, or just a unit that is to exercise prudence against corruption. What about supervision and monitoring this, or what about the activities, anti-corruption activities in your case? Thank you. Well, as far as I remember, well, frankly speaking, thinking about what functions are planned to be given over to central bank, one is tempted to say, let us delegate on this and that and everything. But central bank will have hard time digesting the functions delegated to it right now already. So of course we central bank can consume more and more, but it would be a wrong thing to do, really. So as for the technical supervision, well, actually these functions has already went over to the central bank. Oh yes, it has. Okay, we have one more speaker for today, and I'm giving the floor over to Andrei Medvedev, and I'm confident that Andrei will be able to elucidate in more detail, which I failed to do, just about the roadmap. What specific steps are planned during this transition period? Oh, thank you very much. I'll try to minimize my presentation, leaving most time for questions and answers, and also realize that people are exhausted towards the end of the day. So I will start indirectly tackling the questions raised in this audience before. It was about unified regulator and about building the environment. And the key issue here is that of the quality of normative acts and regulations and the quality of those that are already adopted. And the main issue is that of law implementation or law enforcement. And Kazakhstan experience tells us that, and also in our International Financial Center, we discussed it not once. We discussed the need for the unified or integrated financial court on a supranational level. This was, without this, we won't be able to achieve any qualitative improvements. Well, there was some question about the inside law. This law still is still active. There are some court bylaws and cases about manipulation. As for inside, this issue is more complicated, but within the framework of the existing system, just questioning those bylaws within the court system when the judge considers the issue related with a totally different sphere of regulation, and then he has to switch over to the specialized area, the area requiring specialized knowledge in a narrow field. It's very difficult, and it's very difficult to assure the effectiveness of such courts if we follow the existing tradition. They must take into consideration the specificity of financial markets, the speed of transactions in these markets, and so on. One more question was asked about the conflict of interests. Oh, of course, there are several decisions made. It's judgmental issue. Never in the practice of those markets there has been a process when the parties would admit it in writing that they have a conflict of interest, because this is a judgmental conclusion, and proving that there is a conflict of interest is possible only having the effective court system and law enforcement system. And the developing practice now, according to the order for the Supreme Arbitrage Court, the courts, there will be specialized courts tackling only this type of cases, and then the quality can be assured. Quality can be assured by the adequate professional level of the judge. So the second thought is kind of a refrain about the above said, about the decisions made. Any decision on the financial market can always be perceived twofold. When there are a lot of market participants, majority stockholders, minority stockholders, oil and gas companies, and so on and so forth. So any decision will be met controversially, with mixed feelings. We are always striving towards the balance of interests, and this balance of interests will assure the adequate quality level of regulation. Assessing the efficiency of transactions, well, we can assess the efficiency only by the results, by the outcomes. And before we get outcomes, several years have to pass. So to evaluate decisions made within 2 or 3 months is impossible. So this gives me a smooth transition over to another issue. We are now at the stage of creating this unified regulator. As you know, the draft law is already written and it went through the first hearing. Tomorrow it will be considered in its first reading at the plenary session. So far it has been approved by everyone in the first reading, and doubtless any reforming of the regulator immediately impacts the regulated subject, and negatively at that. Any regulator, if it is changed, will impact some of the subjects or objects of this regulation. So what we are trying to regulate is not uniform. It is a multitude of different entities. One of the goals for unified regulator is this consolidated, continuous analysis of financial condition, financial position. Yes, indeed, it is a recognized need. This is our core thing. But we shouldn't forget that there are a lot of small size, middle size, independent financial structures on the market. And during the transitory period and in further activities in the future, we should build the model to defend the rights of those minor participants of the financial market. And in the financial sector, there are a lot of supervised subjects, entities, and of course we can't defend their rights within the framework that there is. Only a special law can do that. So now we are planning the special law on unified regulator, and in the draft a lot of attention is given to the stability of legal regulation for the participants of the process. The stability for the participants means, or should mean, the stability of legal regulation should mean that there's some continuity of this function will be assured. And most important is not to have any legal vacuum. After the crisis of 2007 and 8, with great intensity, normative acts have been designed and passed, aimed to increase the efficiency of the structure. We can even claim that we have created a new infrastructure of the financial market. You, being participants of the market, very well know that now we have the central depository, we had this law and bylaws, and we can confidently say that they were on a high quality level, and they take into consideration the requirements of international organizations, OSCE and G20 and so on. And then there is a system of clearing, counteragent, United Stock Exchange. And in the sphere of regulating, well, this provides for higher reliability, the listing system, and this reforming is going on. There's reforming of repo market and futures exchange tools market and so on. So now we have numerous bylaws and normative acts that are in operation and that the market uses as guidelines. The Bank of Russia will becoming a unified regulator entails some questions. The Bank of Russia is not subordinated to the government of Russia. It's an independent body which is stipulated by the Constitution of the Russian Federation, which will have highly positive effect. The Bank of Russia will be able to make more prompt, high-quality decisions and bylaws. But even now we have bylaws, and for transitory period, before the Bank of Russia issues its own set of regulations, we need those bylaws to provide us some guidelines. So we are now building the stability of our financial sector regulation. Till the moment the central bank issues its own guidelines. This concerns, among other things, the bylaws of the government of Russia, financial bodies of Russia, and other bodies that regulate relations in the financial market. This system will decrease the uncertainty for the market participants. Well, they say that we're running out of time. Okay, I'll speed up. So the next element, to provide for the stability of the participation, for the participants, we need to acknowledge all the previously issued licenses, permits, accreditations, and so on, that were issued not only by the FSB of Russia, but also by the Federal Insurance Agency, and MPF systems, and others. So this should be assured on the level of legislation. Then the Bank of Russia de facto will well, actually, we are eliminating FSR of Russia, so of course we can't say that the Central Bank of Russia will assume its functions. But anyhow, all the procedures that were initiated within the FSR of Russia prerogative, issuing licenses, permits, and other functions, then trial resolutions of disputes and other functions like this will be continued by the central bank. All the legal procedures initiated by it, they will all be brought to some logical end. Same about the civil right obligations. So the stability of the financial market during the transition period, needs a model, and so this the model of an independent model. In other words, for supervised subject entities, it is very important. Waking up on the morning of the 2nd of August, they shouldn't see anything dramatic happening. So we should keep the people who used to do those procedures and who are knowledgeable about them, and thus a special service will be set up, and people from FSR will be employed there. Then, as it has been said, we have a roadmap, and this roadmap provides detailed guidelines and just describes the distribution of the allocation of responsibilities. Then this service will be integrated into the whole system, and the 1st of January 2015, by that time, the specific mechanisms for the financial market regulation will be worked out. We don't know whether it will be by industry or by product, industry-oriented or product-oriented approach. It's not, I don't know yet, but somehow it will happen. So, as of today, what priorities there are for regulation, and what should be implemented within the shortest period of time? As has been said, one of the reasons for building this unified regulator is that since monetary funding is limited, then kind of human resource pool can't be expanded. So all that makes it difficult to organize supervision. So de facto now this supervisory activity bears a formal nature. When inspectors only reveal technical breach of rules, and we should change that. We should increase the number of people working in this sphere, and we should strive for a new system when we control only the essence of the processes, not like firefighters trying to push the symptoms and extinguish fire, which is already rampant, but at the proactive stage, when the problem is only emerging, we should monitor the crisis and try to impact it. So this should be achieved through the modernization of the accounting system. This strategy has already started since the merger between the insurance and FSR services. The monitoring system, there are gaps within it. So new information support system has been developed. Now all the reports are submitted electronically, and we will continue that in the future. And in the future we want to see the issue of all the bylaws and other regulations in an electronic form, and so on. What should be noted? Yes, I'm bringing that to closure. So as for supervision and control, the main goal is to provide, provide defense against risks. But how? So each segment of the financial market functions in its own way. It has its own rules of life, and we simply can't exercise uniform rules of supervisions towards all the entities. It's impossible. For example, valuation of capitalization can't be the criterion for evaluating the company and its solvency. And so on. Well, I'll skip this. And the second stage will be about further development of the laws in compliance with international laws in this sphere. Okay, so here I will end my presentation. Thank you very much for it. So even the equipment is tired now. Let's summarize, dear colleagues. Let us thank Andrei for his presentation, because this issue is very important, understanding all the technical procedures and the legal foundation and all that serves to maintain the full-fledged life of the financial sector, even under the crisis conditions. Dear colleagues, I am really admiring your patience and attention. On behalf of all the moderators and speakers, I thank you for participating in this session, and I'm strongly hopeful. Well, yes, thank you for your criticism, and I'm strongly hopeful that our presentations were of interest and useful. So let us thank the speakers of my panels for their presentations, and have a nice evening in St. Petersburg. Что? Дитя зовет?
Да мама там уже гуляет. А что такое? Она просто ей трудно не ходить с коляской.
Ну что, она же уже вышла.
Она без коляски пойдет.
А Андрей ушел уже на работу, да?
Андрей уже ушел.
То есть некому вместе кататься. Соседей попросить. Я всегда соседей напрягала, потому что мне тоже в Москве было дети с коляской абсолютно.